This is corporations. The issue is whether a minority shareholder has a right to examine books and records. By statute and common law, a shareholder may inspect and copy records only if 1. A demand is made in good faith and for a proper purpose. 2. He describes with particularity his purpose and the records he desires to inspect. And 3. The records are directly connected with his purpose. Enforcement of a shareholder's statutory inspection right is through an equitable proceeding. The shareholder should give a written notice and allow time for the corporation's response. Demand on the corporation. A shareholder must make a demand on a corporation to bring a derivative suit. A shareholder lawsuit for a dividend payment is an individual suit and does not require a demand. Business judgment rule. Business judgment rule protects directors from liability for breach of their fiduciary duties. Business judgment rule is a presumption that in making business decisions, the directors act on an informed basis, in good faith, and in the honest belief that the action being taken is in the best interest of the corporation. The decision of whether to declare a dividend is generally within the director's business judgment. A shareholder has no inherent right to be paid a dividend. Shareholder must prove the director's refusal to declare a dividend amounted to bad faith, fraud, or an abuse of discretion. Earmarks of bad faith include intense hostility of the controlling faction against the minority, exclusion of the minority from employment by the corporation, high salaries, bonuses, or corporate loans made by the officers in control, the fact that the majority group may be subject to high personal income tax if substantial dividends are paid, and the existence of desire by the controlling directors to acquire the minority stock interests as cheaply as possible. However, if these earmarks are not the motivating cause of the board's dividend decision, they do not constitute bad faith. Directors may legitimately decide to retain corporate earnings to expand business, to anticipate losses, or to provide for a stable dividend policy in the future rather than to pay a current dividend. The court will look at all the circumstances surrounding the corporate policy decision in the light of the corporation financial conditions and requirements. Whether a annual meeting of shareholders receives sufficient votes to approve a motion. Corporation must determine shareholders eligible to vote as the record date and provide notice of a shareholders meeting. Only shareholders of record on the record date are entitled to vote. At the meeting, a quorum must be present, usually a majority of the shareholders entitled to vote at the meeting unless otherwise stated in the articles of incorporation or bylaws. And any vote must be affirmed by the percent of shares stipulated in the articles of incorporation or bylaws. Bylaws contain rules and regulations of the corporation and can include any provisions that are not inconsistent with the law or articles of incorporation. Corporation's articles of incorporation will set forth set the amount of shares authorized to be issued. When a corporation purchases back from a shareholder previously issued shares, those repurchased shares are known as treasury shares. Treasury shares have no voting rights. No corporation may vote its own stock. Corporate existence. Under the Model Business Corporation Act, the MBCA, corporate existence begins when the articles of incorporation are filed. This date of filing rule applies even if the articles recite an effective date prior to the date of filing. The MBCA allows the parties to specify a delayed effective date, but not an earlier effective date. Personal liability. Under the MBCA, all persons purporting to act as or on behalf of a corporation, knowing there was no incorporation under this act, are jointly and severally liable for all liabilities created when so acting. Thus, both participation and knowledge requirements must be met. When a corporation's articles of incorporation have not been filed, a person is liable for pre-incorporation transactions only when the person purporting to act on behalf of a corporation not yet formed possesses actual knowledge that the corporation's charter has not yet been issued. It is not enough to establish liability that the person should have inquired about the entity's status and should have known that the corporation was not formed, as those facts do not rise to the level of actual knowledge required. Special meeting of the board. Unless the articles of incorporation or bylaws provide otherwise, notice of a special meeting of a corporation's board of directors must be given at least 2 days prior to the date of the meeting. Notice must include information regarding the time, location, and date of the meeting, but does not need to include information regarding the purpose of the meeting. Proper notice of a special meeting. A director who does not receive notice of a special meeting of the Board of Directors at least 2 days prior to the meeting has not received proper notice of the meeting. However, a director who attends a special meeting of the Board of Directors despite not receiving proper notice waives such notice unless the director objects to the holding of the meeting and thereafter does not vote at the meeting. Quorum. In order for action to take at a special meeting of directors to be proper, a quorum must be present at the meeting. Unless the articles of incorporation or bylaws provided otherwise, when a corporation has a fixed number of directors, a quorum consists of a majority of that fixed number. Director participation. Unless the articles of incorporation or bylaws provide otherwise, if a quorum is present when a vote is taken, a majority vote of directors present is an act of the Board of Directors. In order to vote, a director must be present at the meeting. If not prohibited by the articles of incorporation or bylaws, a director may participate in a meeting by conference, telephone, or similar device, provided that all those participating in the meeting can hear each other at the same time. Fiduciary duty. A majority shareholder in a member-managed limited liability corporation owes a fiduciary duty to both the LLC and its partners. Majority shareholders' duties include the duty of loyalty and the duty of care. Duty of loyalty requires a member to share any misappropriated gains with the LLC. Where a member has usurped a corporate opportunity, the court may find that a constructive trust exists for the income or profits derived through the misappropriation, with the LLC as the beneficiary, and order him to convey to the LLC any income or profits derived through the misappropriation. Duty of care requires that a member act in the best interest of the LLC. Derivative claim. A member may bring a derivative claim against one of its members on behalf of the LLC. A member can bring a derivative claim where 1. A demand is made to the other members to bring the action and the other members fail to do so, or 2. Such demand would be futile. A member can only bring the claims on behalf of the LLC and not himself because these claims belong to the LLC. Any benefit gained by the claim would flow to the LLC and not the member bringing the claim. Dissolution. A member may seek an involuntary dissolution of an LLC where the LLC is acting in a way that is oppressive and harmful to its members. Oppression exists where a majority shareholder violates the reasonable expectations of a minority shareholder. Members of an LLC are liable for losses up to the amount which a member contributed to the LLC. The division of profits does not dictate how losses shall be allocated. Losses are to be paid by the LLC, but if the LLC lacks funds to cover the expenses, the members will not be personally liable beyond the scope of their contributions unless a court pierces the corporate veil. Conflicting interests. A director's conflicting interest transaction is one between the corporation and the director of which the director had knowledge and a material financial interest. A direct financial interest means a personal profit or profit for a close family member. A director's conflicting interest transaction is permitted if the material facts have been disclosed and fully described to the board, and the transaction is approved by a disinterested majority of directors. Once qualified directors authorize the transaction, the business judgment rule applies. If, however, the self-dealing transaction is not properly authorized, the business judgment rule does not apply. Duty of loyalty. Each director of a corporation has a fiduciary duty of loyalty to the corporation not to promote their own interests in a manner injurious to the corporation. A breach of the duty of loyalty may arise where the director has business dealings with the corporation in which the director has a direct financial interest. However, a director has not breached his duty of loyalty where the transaction was fair to the corporation. The court will determine 1. Whether the transaction price was comparable to what would have been obtained in an arm's-length transaction, and 2. Whether the process followed by the directors in reaching their decision was appropriate. Duty of care. Directors of a corporation must perform their duties in good faith in a manner reasonably believed to be in the best interest of the corporation, and with such care as a person in a likely position would use under similar circumstances. A director may be liable for harm to the corporation where it is proven that the director was not informed to an extent the director reasonably believed appropriate in the circumstances. Creation of an LLC. Every LLC must file articles of organization with the Secretary of State. This document is also known as a Certificate of Organization. LLCs with more than one member ordinarily enter into an operating agreement that may include how all the operations will be run. The agreement also sets forth how to share profits and losses among the members. This agreement is similar to a corporation's bylaws. If neither the Articles of Organization nor the operating agreement contains a provision to appoint managers, then the LLC is member managed by default. Agency. An agent acting within the scope of his authority can bind a principal to a contract. Actual authority can be given to an agent expressly or through implication. General agent is employed by a principal to transact all businesses of a particular kind. Actual authority gives the agent the power to take all actions expressed or implied in the principal's manifestation and all actions necessary or incidental to achieve the principal's objectives. In contrast, apparent authority arises based on the principal's representations made to a third party that the agent is acting for the principal, and the third party thus is led to believe that the agent is acting with authority. It requires overt action by the principal. Under agency law, parties cannot disclaim an agency relationship if in fact one exists. Finally, each member in a member-managed LLC has equal rights in the management of the LLC's ordinary business activities, unless expressed otherwise in the operating agreement and the other party has notice of that limitation. Withdrawal. A member may voluntarily withdraw from an LLC, creating a dissociation. Unlike partnerships, a dissociation from an LLC does not dissolve the LLC. The dissociating member has no right to have the LLC buy out his interests unless the operating agreement provides for reimbursement, a buyout, or dissolution. The dissociating member will be paid when the LLC dissolves, if ever. The dissociating member is still entitled to distributions up to the amount of his share, but has no power to force distributions or to manage any LLC business affairs. A member can force dissolution by court orders on the grounds that 1. The conduct of the LLC's activities are unlawful, 2. It is no longer reasonably practicable to carry on the business, or 3. The managers or members have acted in a manner that is illegal, fraudulent, or oppressive and directly harmful to the member. Inspection of documents. Under the MBCA, shareholders have the right to inspect board minutes and accounting records if they have a proper purpose for doing so. Proper purpose is any purpose reasonably related to a shareholder's interests as a shareholder. Proper purpose includes a desire to investigate potentially illegal transactions or any other activities posing an economic risk to the corporation, where there is some credible evidence of a potential issue. Derivative claim. Dismissal. A board of directors can seek dismissal of a derivative suit when a majority of directors who do not have a material interest in the derivative action determine, in good faith and after conducting a reasonable inquiry, that continuance of the suit would be detrimental to the corporation's interests. Failure to investigate credible allegations constitutes a lack of good faith. Business judgment rule. A director is liable to the corporation for decisions or failures to act not undertaken in good faith. A director cannot act in good faith when committing or allowing the corporation to commit illegal acts, even when doing so is profitable for the corporation. Business judgment rule only protects the honest business judgment of directors when rendered in good faith. A corporation existence. Corporation is ordinarily created and comes into existence when the articles of incorporation are filed with the Secretary of State. Creditor of a corporation may seek to enforce corporate liability against persons who knowingly purported to act as shareholders or as agents of the corporation when the corporation did not, in fact, exist. In such cases, the shareholders or agents are jointly and severally liable for all liabilities created while so acting. De facto incorporation. In the absence of a corporation, persons who carry on a business for profit are considered partners in a partnership. A corporation organized in compliance with the statute is a de jure corporation. However, if statutory compliance is insufficient for de jure status, a de facto corporation may still have been formed if 1. A good faith colorable attempt was made to comply with the incorporation statute, and 2. The corporate principals in good faith acted as if they were a corporation. Corporation by estoppel. Absent de jure, de facto status, a corporation may still exist by estoppel. If a creditor always deals with the principals as if they were a corporation, he will be estopped from later alleging that the corporation is defective if that would unjustly harm the principals. Right to inspect. Demand is made in good faith for a proper purpose. Describe with particularity the purpose in the records to inspect, and the records are directly related to that purpose. Shareholders generally able to show good faith that they present evidence establishing a credible basis for belief in possible wrongdoing. Proper purpose is one that is reasonably relevant to the demanding shareholder's interest as a shareholder. Is a proposed resolution a proper subject for submission to a shareholders for vote. The submission of shareholder resolutions for shareholder action at shareholder meetings is generally accepted under common law principles as a fundamental right of shareholders. Shareholders may express their views on corporate matters in non-binding precatory resolutions. Shareholder proposals cast as recommendations or requests that the board of directors take specified action are generally proper. However, a shareholder proposal that would bind the corporation or the corporation's board is generally not considered proper. The expectation would be when the shareholder resolution seeks to require corporate action by means of an amendment to the bylaws. First Amendment, free speech. First Amendment applies, which is applicable to the state's due process clause of the 14th Amendment, provides Congress shall make no law abridging the freedom of speech or the press or the right of people peaceably assemble or petition the government for a redress of grievance. Supreme Court has ruled corporate spending on speech merits the same First Amendment protections as speech by natural persons, hence Congress may not censor such corporate speech. Merger. Shareholder approval is required to make fundamental changes to the corporate structure. Two or more domestic corporations may merge into one corporation under a plan of merger that must be approved in accordance with statutory procedures. Board of directors of each corporation must adopt a plan of merger by a majority vote. The plan must be submitted to a shareholder vote for approval unless such vote is not required. MBCA requires a vote of the majority of the shareholders. Shareholder has a right to dissent from a merger or consolidation if the shareholder has a right to vote. Dissenting shareholders have the right to require the corporation to appraise the shares and buy them at fair market value. The dissenting shareholder must file with the corporation before the shareholders vote written objection to the proposed action, stating that he intends to demand payment for his shares if the action is taken. The dissenting shareholder must not vote his shares in favor of the proposed action. Benefit corporation. Benefit corporations are for-profit corporations whose corporate purpose includes the benefiting of the public. In a benefit corporation, because the pursuit of a general public benefit is not secondary to the pursuit of profits, directors have protection against claims of corporate waste when pursuing non-profit making activities that would not otherwise exist in a traditional corporation. It's agency. Director's conflicting interest transaction is a transaction by the corporation to which a director is a party. Traditionally, such transactions are void. Under the modern trend, conflicting interest transactions may be approved by fully informed disinterested directors. Without approval, such transactions will only be upheld if it were fair to the corporation. Transaction is fair to the corporation where it benefits the corporation has the same result if it would have been an arm's length transaction. That is judicial dissolution. Under the MBCA, court has the discretion to dissolve a corporation if a minority shareholder can show that the majority shareholder is behaving in an oppressive manner. Behavior may be oppressive where it violates reasonable expectations of the minority shareholder. Shareholder has the right to inspect the account records of the corporation. That is corporations.